Okay, guys, we're back this week. Do y'all have any questions about what we went over last week? No questions? Nothing? Okay. All right. So this week we're going to do chapter 12. How to report objections. Okay? The objectives is to discuss in detail the philosophy of objections, why they are used, and how they are used in a legal proceeding. 2, to explain how to anticipate and handle objections that are made by an attorney during a court proceeding, and to list and explain the various grounds for objections. Okay? One way that lawyers protect the interest of their clients is through the use of the rules of evidence. The rules of evidence are procedural guidelines by which attorneys and the judge can conduct the litigation process. The rules of evidence fill many books and state what is allowed and what is not allowed in the presentation of a case. Okay? So if they want to present evidence or they want to present certain things, there's always procedures that they have to follow. Okay? They can't just do things because they want to do it. They have to follow certain guidelines, and if they don't, then it's not going to be admissible. Okay? Evidence includes all of the means by which any alleged matter of fact, the truth of which is submitted to investigation, is established or disproved. Evidence includes both oral testimony and physical objects, such as exhibits introduced in a case. Attorneys are expected to protect their record by making timely use of objections and motions to strike during legal proceedings. These objections are essential to preserve the right of the litigants. Okay? So they can't go on and they're presenting this evidence and then he goes, oh, you know what? I want to object to the answer that he gave 4 questions ago. You can't do that. Okay? And you have to object before the witness gives the answer. Usually. Because then the judge will say, you know what, that objection wasn't timely. So then it's allowed. Okay, so they have to be careful about how they present it. A lawyer who fails to object to evidence ordinarily waives claim as to its inadmissibility. So if they don't object, then it's admissible. Okay? The judge will rule on all objections, sustaining proper ones and overruling improper ones. Sometimes objections are stated as motions in which the judge will grant or deny the motion. So those are objections too. They're going to object to, say a guy got pulled over and let's just say the cop was just bored and just pulled the guy over. Well, you have to have probable cause to pull somebody even over. So they, can object, you know what, well, he didn't even have probable cause to pull him over. Yes, he was drunk, but I mean, he was driving straight, everything was great. So if he didn't file a motion, then it's going to be admitted. So they have to file motions, in order to get certain evidence taken out or not admitted. In some states, opposing counsel is considered to have an automatic exception to court rulings adverse to his or her side of the case. In other states, attorneys must note their exception, which is a disagreement, with the ruling by so noting on the record. So if they don't agree with the ruling, then they say, note my exception. So if it goes up to the 4th court, then they have something to go on appeal. Okay? Anticipating and marking objections. Most court reporters learn to sense immediately when an objection is going to occur. They can tell by the nature of the question or by the response given by the witness. This anticipation makes the reporter ready for the ensuing exchange of words that will usually follow a pattern of objections by one attorney, response by the other attorney, an exchange between counsel, eventual ruling by the court, and possible exception by the ruling of the attorney. So a lot of times you can kind of get the feel of whether, you know, there's an objection coming. A lot of times they'll stand up. So whenever you're going to address the court, they want you to stand up. So a lot of times you can already see, he's already asking the question, the guy's already standing up, waiting for him to finish the question, and you already know there's something coming. Or you can just, you know, you can be taking stuff down and just kind of look over, and he's already like that, leaning over to where he's going to get up, and you already know by his actions what's going to happen. So you already anticipate what's going to happen. So you have his symbol ready for his objection, okay? So you, I mean, you kind of get to know what's going to happen. Most reporters also realize that the question and answers that were given right before the objection will probably have to be read back to the court as a point of reference. As a result, good reporters mark the spot in their notes where the objection began and then quickly go back to that spot to find the correct place for the readback. I think you asked me that the other day. Didn't you ask me that question the other day?
Yeah, but it was more referring to, I didn't know whether they were talking about like on the machine since we don't have paper now.
Oh, okay.
Because they were talking about how you mark it with the ink, and here it talks about that. But when you have your like your diamante, like how do you do that? And you're marking your spot, and then they're talking and talking and talking, and they ask you, okay, go and back, like you've gone on for so long that they're talking. How do you do that on? You know what I'm saying?
Well, I mean, you should have your computer open. So you should have your laptop there. You're writing to the judge's laptop. So all you have to do is either scroll up, or if you want to read from the machine, like my writer is a Diamante. So it doesn't have where you mark something on the paper. But it has a button there for the last question. So that's all you do. You push that button, it goes up to the last question. It doesn't matter if it was 10 pages. If they did 10 pages of objections, you push that button, last question, it takes you to the last question that was asked. And if it was 2 before that, then all you do is just scroll up or just keep pushing that question button and just go to there.
It'll go from the last question and the previous question?
And then the previous question, then the previous question, then the previous question. So say they say, well, I object to her answer. I object to her answer. All of it was hearsay. I don't even remember what she said. What was she saying? Well, she was saying that the doctor said it. No, she said that the doctor told her, blah, 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 you know, and if it was telling her, then, you know, I don't even know if that's... Anyway, they're going to make an objection and they're going to say, you know what, well, in that answer, she was saying, that's who she was talking about. She was saying that the doctor said it, not that she said it, the doctor said it. Well, no, I don't think so. Well, you know what? We'll have the reporter read it back. So don't freak out. Oh, on the Diamante, it only has the last question. But don't freak out. You go to the last question and then just scroll down to the answer. And then that's where you read it. Okay? So you don't have to, you know, if they went on for 2 or 3 minutes on this objection, well, you know, it's not part of the law and it's hearsay and blah, 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 and they go on, and then, you know, this attorney says something, and this attorney says something, blah, blah, and they just keep going back and forth, and the court interjects, well, I don't think it is, and you know what, we'll just have it read back and we'll see. Push last question, goes up to the last question, no big deal. Scroll down from there, take it from the answer, then just read from the answer. Okay? So really, I mean, the machines don't have mark now. Not the one that I have. It doesn't have a mark. Okay? And they're saying there's various methods are used for reporters to mark their notes. Some reporters use a device connected to their cover plate that, when used on the left or right side, will automatically put a small ink spot. You know, and this was in the old days. I don't know when this thing was written, but it doesn't do that anymore. Okay? That was back in the paper days, I think. You know, back when machines had paper. So it doesn't do that anymore. And they used to do that, remember?
Yeah. Remember, we used to grab a pencil real quick.
Yeah. So, oh, here it is. When using a paperless machine, the reporter will use a special designation to mark spots where objections are made in order to find an easy reference point to refer back to, for example, hitting the upper and lower bank of the keys. Well, that's okay, unless you use my method of speaker identifications. Then it's going to say attorney 1, attorney 2. So what they're saying is the way that they mark it is they hit up or lower. Okay. Mine's going to say attorney 1, attorney 2, you know. But I mean, you know, if you want to mark, I mean, you know, like I said, there's easier ways to do it. They're just kind of giving you different examples of how you can do it. You know, you can hit something on your machine, you know, mark. I don't know, you know. Oh, that's gonna, all it's gonna do on mine is it's gonna say exhibit mark 3 times.
My machine has one, when you push the button, it says mark in parentheses, and it's a different color. Mine happens to be purple.
Really?
And then you just press search,
Yeah.
and it'll go to the last mark that you
Mhm.
You have several marks, and you'll go out.
Yeah.
So, mine
You in the back.
When you're reading back something, say it's several questions and
Mhm.
answers, and you come to, obviously you're reading ahead, you see an objection's coming up,
Mhm.
so you don't read that last answer. How do you read back? Do you stop reading and that's it, or do you say, and following was an objection that was sustained, or how do you go about reading that back when there's an objection in there? Do you state why you stop because there's an objection, or you just stop reading at that point? I don't know if I got that out.
Yeah, I'm not sure if I'm following you correctly, but I mean, if I'm getting the gist of what you're saying, you read what they have. So you read it up to the, if they say, you know what, read it all back. And they'll get to a point where they're not gonna want the objection. They already know the objection. They made the objection, so they already know that. So they're not gonna want the objection read. Is that what you're saying?
Right, so will they stop me and say, okay, that's enough, or?
Usually they'll say, you know what, read back the last question and answer. Or a lot of times they'll say, you know what, we object to the form of the question. And blah, blah, and blah, blah, and blah, blah, back and forth. And then they're like, you know what, just either restate your question or, you know what, if the court reporter would just read back the last question. Because most of the time, their minds are thinking so fast that they forget the question. And if it's like my judge will tell them, ask another question then, you know. Very seldom do I have to read back, but I do. Every now and then he'll say, you know what, I don't even remember the question. How exactly was a question phrased? You know what, Dave, read that back. Read that question back. Push that button, goes back to the last question, and I read the question back.
So typically, read back is asked one question or answer at a time.
Usually, yeah.
Okay.
Yeah. So it's an objection to something. So usually, like in a deposition, you know, the attorney will ask a question where you can object to the form of the question and something else. There's only so many objections you can make in a deposition, and usually it's to the form of the question. You know what, I object to the form of the question in a second. And it's so funny because, like, the guy just asked a question, he's like, I don't even remember what the question was. Really? But they do. So it's like, you know what? Read it back. And I had an attorney, holy cow. Every time they made an objection, he wanted it read back. Every time. So, you know, you can't get lax and just like, oh man, you know, I want to go home and start thinking, you know, whatever, and you're just kind of, you know, slapping the keys around or whatever. You know, that's why you have to pay attention, because you never know when an objection is coming or when they're going to ask you to read back. Did I answer your question? Atta girl. Yeah. Read it back. Okay, how to handle objections. When a question is asked and the opposing attorney interjects an objection, the discussion that follows may get pretty hot and heavy. The attorneys in the heat of the argument may speak very quickly, and in some cases both attorneys may speak at the same time when the judge is trying to interpose a ruling. If an electronic recorder or recording were recording what occurred, you may have a garbled mess to untangle what would be very difficult, if not impossible, to decipher. A court reporter has the advantage of stopping the attorneys before they get out of hand and remind them that only one person should speak at a time. Guys, I'm telling you right now, you have full reign in that courtroom, okay? There's very few judges that won't let you say, I mean, I don't know that I've ever had it. But I had some reporters tell me, I mean, the judge told me not to say anything, not to stop them. What? You're responsible for that record, you know? So if you're not getting it, you have to tell them. Slow down, speak one at a time, or speak clearly. You know, and I had it today. Had a lady speaking so low, had no idea what she was saying. You know, it's like, ma'am, pull the microphone up, and speak clearly. And she would do it, and then right at the end of the sentence, I didn't get it. And my judge is really good about, you know, speak up, speak up. Because if he can't hear it, he has to hear it too. Because he has to understand what he's hearing in order to be able to rule certain ways if it's, you know, because it's part of the evidence. Well, you're responsible for that record too. So it's like, you know, hopefully the recorder was getting it. Don't count on that recorder. Do not. Because if they ask you to read back, then it's like, well, I didn't get all of it. Well, then you should have stopped them and told them to repeat it. Yeah, I probably should have. So don't get to that point. You know what I'm saying? You have full reign in that courtroom. So if you're not getting it, and attorneys, you know, their minds think really quick. You know, so they're just trying to get it out. You know, and when you're fighting, you don't wait for the other person. Oh yeah, well go ahead and say what you need to say, and then I'll say what I need to say. No, it's usually boom, 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 boom. So that's why I'm saying, you know, there's times when, if that software is right, I've written 300. You know, just because the exchanges are so quick and whatever, and you're just hanging on. But it's so quick, and they're staying in line, and they may be speaking over each other a little bit, but if I'm getting it, you know, I won't stop them. But if I'm not, absolutely I will. Okay? So that's how you handle it. I mean, you have full reign of the courtroom, so if you need to tell them something, you do. During these periods of objections, always record the question and answer because they are essential. If you can, mark them somehow because they may have to be read back. Then record the fact that an objection occurred and the record as much of the grounds for the objection as you possibly can, preferably verbatim. You will have preserved the record in that manner for appeal. I mean, you have to do that anyway. I mean, you're supposed to do that anyway. So I'm not quite sure what they're saying there about marking the objection because it may have to be read back. I'm not sure. Next, ensure to record the ruling of the court. If the objection is sustained and an answer already had been given to the question, the opposing attorney will make a motion to have that answer stricken from the record. Okay? So if it's already been read and he goes, you know what, that it was hearsay, sustained. And the opposing counsel is going to stand up and say, you know what, Judge, I want that stricken from the record. Well, it doesn't mean that you erase it from the record. Okay? It just means that's for appellate purposes. So if it goes up to another court or whatever, then they know that that evidence was not to be considered because it was stricken from the record. But you don't keep it out of the record. Okay? Grounds for objections. When objecting, attorneys may voice general or specific grounds. The grounds for an objection are the reason that the attorney gives in support for raising the objections in the first place. When an attorney says objection or we object, or state that they object to the form of the question, they are making a general objection. When an attorney gives a reason for the objection, he or she is making a specific objection. Incompetent, irrelevant, and immaterial. These are some of the objections. Perhaps the most common form of objection is object to the evidence on the grounds that it is incompetent, irrelevant, or immaterial. It is called a blanket objection and may include other grounds to make the objection more specific, such as the fact that the question has no relevancy to the matter under consideration. So if they're asking questions, just to kind of give you an example, and maybe they do give you, and they do. To your knowledge, is Samantha Smith a prostitute? And the attorney, I object to this, incompetent, irrelevant, and immaterial. How could her profession matter in a robbery case? Yeah, so if she was robbing, it doesn't matter whether she was a prostitute, drug dealer, whatever. I mean, maybe it would. I mean, it would show why she was robbing to go get drugs or whatever. I don't know. You know, but usually they're going to object to relevancy. I don't think I've ever heard incompetent. I don't, in the 23 years I've been a reporter, I don't think I've ever heard object to incompetent. Usually it's object to relevancy. Well, it's not relevant to the proceedings. Well, how is it relevant to the proceeding? Well, she was robbing because she had a drug problem. She was a prostitute, had a drug problem, and that's why she was robbing. I don't know. So, I mean, you know, I guess you'll hear it or whatever, but I've never heard it in the 23 years that I've been doing it. I've never heard object to incompetent, but whatever. Leading and suggestive questions. Another very common objection is object to the question as that is leading or suggestive. So this happens when the person who calls the witness can't ask leading questions like, you went to the store, right? You shot that guy, right? That's suggested. It's suggesting that you did it, you know. And my judge, you know, they object all the time as to leading, you know, and our DAs do it all the time. But it's supposed to be what, how, when, or where. What, how, when, or where is the way that their questions are supposed to be posed, because then that's asking a question. Where did you go when the stabbing occurred? Oh, I went to the store. So if it's suggestive, usually it's like a yes or no answer. So if it's a yes or no, more than likely it's a leading question, okay, or suggested.
Putting is in front of it, does that make a difference? Is that right? That's not leading. Is that right? Because if you're saying right, then you're not. So that's leading. But what about is that right?
No, it's the question before. It doesn't really matter whether it's right. Is that correct?
No.
Is that, you know, whatever? No, it's more like you did go to the store, right?
Oh.
You did run over that dog, correct? You know, stuff like that, where they're suggesting the answer, where the question is suggesting the answer. So all the person has to do is say, yeah. So usually if it's a yes or no question, then it's usually leading. It's usually a suggestive question, because they already kind of put the answer in the question. You know, it's not something that they have to give an answer for. Like, well, how did you get to the store? Well, I borrowed my brother's truck and that's how I got to the store. Or I asked my brother for a ride and he took me to the store. Not, your brother is the one who took you to the store, right? That's suggestive. That's suggesting that your brother took you to the store. If they want to find out who took you to the store, that's suggesting who took you, your brother, okay? So it has nothing to do with is that correct or is that right or whatever. It's the question before, okay? Questions are leading when they clearly suggest to the witness the answer desired by counsel. In other words, the attorney is telling the witness what to say by giving her or him the answer to the question. For example, you knew your wife was going to meet this man at 8 o'clock at night on March 23rd at Carmelita's Corner, didn't you? See, it's suggesting you knew she was going over there to meet this man, right? Not why did your wife go to Carmelita's Corner? What, when, where, how, I believe is the way the judge puts it all the time. So do y'all understand what a leading question is? Suggestive? It's suggesting the answer. And it tells you right there. The more proper question would have been, do you have any knowledge of where your wife was going on the night of March 23rd? Okay? But if you didn't call the witness, then you can lead them. It's kind of weird. If you call the witness, then you can't lead. But if it's not your witness, then you can lead them. It's kind of weird.
Is there
But
an explanation to that?
I don't really know. I mean, that has more to do with like law stuff, you know, and why they can and why they can't do it. But the person who calls the witness can't lead the witness. Okay? And it tells you that right there. Leading questions may be allowed when a witness is elderly and infirm, a young child, an illiterate person, or one suffering from a language barrier. Leading questions may also be appropriate on cross-examination. So they are appropriate on cross-examination. They're not appropriate on direct examination. Okay? And the court may ask a leading question to get the truth out. Okay? So it's not really up to us to determine why they should lead, why they shouldn't, you know, whatever. It's just helping you understand why it is what it is. I have no idea why they can, you know, why they can lead on cross-examination, you know, but you can.
I had a quick question, it was from earlier.
Sure.
And it has to do with when you interrupt because you're not getting the record.
Mhm.
Now that I've heard that some judges don't like it when the court reporter interrupts.
Mhm.
Would a more appropriate way of doing it would be to tell the judge, I'm not getting everything, and let the judge handle, or say, you know, one at a time?
Usually you'll know because your judge gives you full reign. The judge is the boss in there. So he's gonna tell them what can and can't be done. It doesn't matter to them. It doesn't matter whether they like it or not. You know what? Don't interrupt me. You know what? I'm not getting it. And usually, like my judge, you know what? You don't tell him when. If he's not getting it, he's going to tell you. And if he's not getting it, more than likely I'm not getting it either, because you guys are talking over one another, or she's talking too low, or she's talking too fast, or you know, whatever. So you'll know. I mean, you have that understanding with your judge and whatnot. But if you're in a deposition, I mean, and somebody tells you something, then you just tell them, and respectfully, I mean, you just tell them, look, I'm not getting it, guys. I'm not. You know, you guys are talking over one another. I'm not getting it. You have to speak one at a time. Okay? And usually, I mean, they're pretty considerate about it. They really are. And like I said, in the 23 years, I've never had anybody tell me, you know what, boy? Don't open your mouth no more. I've never had anybody tell me that. If I'm not getting it, I'm not getting it. And usually by the third time, and we have one DA that's real bad or whatever, and I'll tell the judge, I'm not getting it. I'm not, and then he really raises his voice. And he'll really get after him. So usually it keeps me from having to do it. But if I have to do it, then I do it. Because, you know, they just keep doing it and keep doing it. And finally, I'll just tell them, look, it's your record. You know, if I'm not getting it, it's your record. So, I mean, you know, if it goes up on appeal and it's not there, it's not there. I already told you 3 times, 4 times, speak one at a time. Slow down. Don't speak over one another. And you keep doing it. And I had one of the DAs do it, and I told her 4 times. And finally, the last time I had it. And the judge told me, he was a visiting judge. He said, Dave, don't worry about it. He said, you just get what you can. Don't worry about it. He said, it's her record. If she didn't want it there, then when it goes up on appeal and nobody can figure out what she's saying, then it is what it is. After that, she slowed down, you know.
Do those comments go on the record? Like you telling them to slow down?
Oh, yeah. Yeah.
You say it and you sit down.
Yeah. And then I'll put,
Actual or
No, I usually put what I say.
Oh.
Usually, yeah.
How do you do that? As you're talking?
I mean, I'll just put it on there.
Okay.
Yeah. So I mean, I'll just say, guys, slow down. Slow down, and then I'll just put it. And I do KRORT, which is court reporter. Is that y'all's brief? KRORT, court reporter.
Or-
That's how I do it. So I do court twice, and then it comes up, court reporter, and then I just put, guys, slow down, speak one at a time. Don't speak over one another. Whatever. So
So does that always cover you if you clearly said it about 3 or 4 times? That comes back on.
it goes up on appeal, and I mean, finally, sometimes and I've done it. It hasn't been a whole lot of times, but I'll just tell them, look, guys, I'm not going to ask you again. I've told you 3 or 4 times, and I'm not going to ask you again. The next time, I'm just going to get what I can. Then they realize, God, maybe we are speaking over one another. And a lot of times it gets personal between the attorneys. So then they're trying to, get at one another, and they're not realizing that they're speaking over one another and whatnot. And some of them don't care. They just keep doing it. So, but usually my judge is really good about doing that. And he'll, like the 3rd time, and he has to raise his voice, things change after that. So, but he's real good about taking control of the courtroom, and making sure, because, the record reflects him as much as it does the attorneys too. And he wants a good, clean record all the time. So he's pretty cognizant of what's going on. Non-responsive answers. When a witness does not clearly respond to the question asked, counsel may object to the answer as non-responsive. And a prime example is, the example they give there, what is your name? Well, my mother, rest her soul, used to call me Tibby. My father still calls me Libby. My husband, well, I won't say what my husband calls me. You know what? They didn't ask you all that. They didn't ask you all that. God almighty, we have a caseworker that's just like that. And, the DA, just beats her down sometimes. It's like, they tell you, listen to the question, only answer the question. Did you do the service plan? Well, I was going to do it, but I didn't do it because my supervisor told me to go do something else. I had to go do a visit, and then I had to take some kids. They didn't ask you that. That's non-responsive. So when they object as non-responsive, that's usually what it is. And usually it's something simple. Did you do the service plan? Yeah. That's all you have to say. God forbid, she just terrible, terrible. But you have those guys that do it, and they want to explain more than what they want to. But it's not up to you to say, what, that was non-responsive, or whatever. It's not up to you. But that's one of the objections that they'll make, is non-responsive. Okay. Lack of proper foundation. Sometimes attorneys will object to a question because no proper foundation has been laid for the question. Evidence should proceed logically, and if a foundation must be laid step by step. And the example is, do I understand then that the only way you advertise is by brochures sent to customers? Part of the foundation for facts may be marking. Okay. And then she objects it. I object. No foundation has been laid to show that the company had any brochures or has ever sent out any prospective customers. Or, a lot of times they object that, they'll start asking, like a therapist, certain questions. Well, they have to lay this foundation. They have to lay the foundation. So usually he gives his name. Well, give us your background. Where'd you go to school? So they have to go, I went, I did my undergrad at SMU. I did my, my main at University of Texas. I did an internship over here, and I've been a licensed professional for 14 years with so-and-so company, okay? And then usually they'll ask, Judge, we want this person recognized as an expert witness. And then they can ask them certain questions, but if you don't lay that foundation, then they don't have the right to ask it. And that's, you know, if you don't lay the proper foundation, then you can't ask certain questions if you haven't laid them out as an expert witness. Does that make sense? Yeah. Facts not in evidence. This type of objection is often used when an attorney assumes facts that are not in evidence. A hypothetical question that does not parallel the case at hand will be objected to on the grounds that it assumes facts not in evidence. Question: did you see Mr. Stone in the same car in which you saw the stolen lawnmower? Your Honor, I object. He has not testified that he ever saw either him or the lawnmower in any car. He is assuming facts that are not in evidence. So if it hasn't been testified to, then you can't assume that it was just done. So those are facts not in evidence. Does that make sense to you guys, that example? Repetitious question, and these guys and attorneys are notorious for doing it. And you'll ask the same question 9 different ways. And it's like, you know, we already got it. We got it. She doesn't know. Well, isn't it true that, you know, you did go to the store? I don't remember. I don't remember if I went to the store. Well, when you went with your brother, didn't you go with your brother? Your brother picked you up and then you went to the store on March 23rd? I don't remember. Well, the convenience store on that side, the little supermarket that y'all went to where the accident happened on this day, don't you remember going? And it's like, you're just asking. She just said, I don't know. I don't know. I don't know if I went to the store. And they just keep asking the same question in different ways. And that's, you know, that's another objection, is repetition. Or asked and answered. You'll hear that a lot. You're going to hear that one a lot. Not necessarily objection to repetitious questions. It's going to be, Judge, that's already been asked and answered. You already asked if she went to the store where the accident happened. She already said, I don't know. It's already been asked and answered. Hearsay evidence. Hearsay evidence is frequently objected to by counsel. Hearsay in a term given to testimony offered by witnesses who testify that do not know personally, but to what others have told them or what they have heard or said by others. It is secondhand information. Okay? So that one you're going to hear a lot. Okay? I object to hearsay. Okay. And some of the examples is, when is the first time you saw Mrs. Johnson that day? Someone called from room 39 and reported that she was there. Well, it doesn't really matter what somebody from room 39 said. They're asking you when the last time. You know, so if it's coming from somebody else, the information is coming from someone else that's not a party in the case, then it's hearsay. But, you know, like in our cases, you know, you have the mom and dad, most of the time they're there, and it doesn't really matter if they're there or not. If they're parties to the case, then you can say what they said. You know, well, mom told me she was going to be positive for that drug test. Well, I object, Judge. She never, you know, that's hearsay. Well, no, she's here, so we can ask her. So usually if it's a party, it's not hearsay. Self-serving answers. Self-serving statements and self-serving documents are objectionable because they serve no purpose other than to bolster the person's case who offers them. Often during the trial of a case, the plaintiff or the defendant will try to justify his or her actions or try to explain a matter in greater detail. During this explanation or justification, the witness will tend to add extraneous matter that will help his or her own cause. Question: when you came to the hospital, you told them that Mr. Hansen ran you down, didn't you? Yes, I certainly did. He did it on purpose. Well, nobody asked if he did it on purpose. They just asked if he did it. and the attorney objected, I object to the question and answer as self-serving. And that's why. Is that clear? Compound and complex questions. Pretty self-explanatory, guys. I mean, a compound question is going to be, did you go to the store that day? And if you went to the store, did you go in with your brother? And did y'all go in your brother's car? And who was with y'all when you went to the store? That's 4 questions, you know? And it should be broken up, and a lot of times they'll, you know, present a question in a certain way to try to get a certain answer, but it's like, you know, you have to ask each one individually. So a lot of times you'll hear, Judge, that's a compound question. Yes. And that's the example. Did you remove the article from the car that was parked on the corner at the time that the man who said he saw you near the gas station ran into the street yelling for you to stop, or did you sit there in your patrol car and observe the men who came out of the terminal because the whistle had blown? Seriously? I mean, all of that information, you know? So it's a compound and complex. You know, a lot of times they're going to lose the witness because they've already asked a whole lot. It's like, I don't even remember what you asked. Ambiguous questions. Vague, uncertain, or ambiguous questions are also objected to because an indefinite and uncertain question cannot elicit an intelligible answer. Ordinarily, upon objection, the court will request that such questions be rephrased by the attorney who asked the original question. Would you say that there is a great likelihood of assuming that if small particles of sand and other debris gets into the system, that there would be a fairly good possibility of the valves wedging closed? Would you say that a very, very remote possibility exists? I object to the form of the question. It's broad, vague, and indefinite. The witness would have to know the location of the material, the exact size of the material, and under what condition the valve was operating at the time. And that's true. You know, so that's what makes it vague, broad. Other than best evidence, sometimes attorneys will present copies of letters or instruments or photocopies of checks and documents as exhibits when the originals could be made available. Also, counsel will sometimes bring in a secondary witness to testify to a matter when a different witness may be better to testify to those facts. Opposing counsel will object to such presentations as to the evidence. Question: I am going to show you what has been marked as Defendant's Exhibit A for identification, a rental schedule of the building in question, and ask you to tell us what Mr. J's renting was during January of last year. And the attorney: we object to this line of questioning pertaining to the rental schedule as not being the best evidence, Your Honor. If counsel wishes to know the amount of the rent, why doesn't he produce the actual signed lease between the landlord and the tenant as to the best possible evidence? Or call the landlord as a you know, because going through him is not going to be the best evidence. And you know, sometimes, prime example, like in our court, you know, they take them for urinalysis. Well, isn't it true that mom said that she was positive for methamphetamines because she took some Bayer aspirin? No. I mean, you'd have to bring in an expert as to that. You know, the caseworker's not going to know whether it is or not, whether Bayer aspirin is going to test as a methamphetamine or not. I mean, so that's not the best person to bring that evidence in. Does that make sense? Call for conclusions or opinions. Objections are commonly made to questions that call for conclusions, opinions, or speculation on the part of the witness who is not an expert. Opinions are inferences or conclusions that are drawn by a witness from the facts. Ordinarily, witnesses may give only the facts and not their opinion on any conclusions that they may draw from the facts. Question: what do you see in the photograph, Ms. Smith? To me, it shows evidence of a blood stain on the front of the seat of the car. Attorney: I object that the answer calls for a conclusion on the part of the witness. Well, yeah. If you're looking at a picture, who knows? Maybe it's ketchup. Maybe it's Kool-Aid. She's just saying what she thinks it is. Well, I mean, that's what it looks like. Now you're speculating. And you're drawing conclusions from something that's not necessarily true. Illegally obtained evidence. A valid objection is often made concerning evidence that is illegally obtained and therefore not admissible. This objection is frequently made against the inclusion of confessions that may have been obtained under circumstances where doubt exists about whether an accused person properly was advised of their rights. Question: I show you now your statement that has been marked as State's Exhibit Number 1 and ask if you can identify it. Attorney: Your Honor, I object to the introduction of this exhibit because it was illegally obtained. My client was not properly advised of his or her constitutional rights prior to the interrogation, and he gave that statement not knowing that he was entitled to the service of his attorney, and blah, blah, blah. Okay, so that's illegally obtained evidence. So if they didn't have a chance to confer with their attorney beforehand, or, you know, a big one is if they weren't given their Miranda rights. So if they weren't told their Miranda rights before and they get a statement, you know, before that, all of that stuff gets thrown out. So it's, I mean, that one's really big. Self-incriminating testimony. When a person makes a statement or gives testimony that may be damaging to himself or herself, he or she is self-incriminating himself or herself. Under the Fifth Amendment of the U.S. Constitution, a person does not have to give incriminating testimony against himself or herself and can claim privilege against this self-incrimination. Question: did you run an illegal bookmaking scheme for the purpose of procuring bets on horses? Attorney: my client refuses to answer that question on the grounds that it might tend to incriminate him. And you'll hear that all the time. You know, especially in our cases, you know, they'll ask, did you beat that baby? Is it true that you hit that baby with a broomstick, or, you know, hit that kid with a broomstick, or slap that kid, or whatever? Well, if there's charges pending, even if there's not, my judge is real good about, whoa, whoa, whoa. And he reads them. He's like, you know what, you have the right to not answer under the Constitution and claim your Fifth Amendment right, which is you don't have to answer. But if you don't answer, especially on the civil side, which is what we do, we're not the criminal side. So on the civil side, if the witness doesn't answer, then the judge can infer what he or she might have said. That's kind of bad on the civil side. On the criminal side, you don't have to say anything. You don't have to say a thing. You don't have to testify. The state has the burden of putting on all of their proof, and you don't have to say a thing. You don't have to put on any evidence. Not in our court. You know, my judge will tell them that's a recipe for disaster. You don't come in and you come clean with everything, then we have the right to infer whatever we need to. So it's like, you know what, we need you to do counseling. I'm not going to go in and do counseling and talk to this guy or whatever, and you know, and then I tell him, you know, yeah, I was the one who shook that baby till he died. Now they have right to bring charges against them and incriminate them for something that they said that can be used against them. And the judge will always tell them too, look, there's a record being made, you know, always look to your attorney as to the question, and if he tells you can answer, then you can answer. If not, then you plead your fifth, and they'll say, you know, I plead the fifth. I plead the fifth. And mine is PLIFT. I plead the fifth. I mean, because we had one, and they have the right to, I mean, the state has the right to answer, and if they even know that they're going to answer it, it's like, you know what, you know they're not going to answer it. Well, we have the right to ask that question. And we spent an hour one time asking questions and knowing that, but I mean, that's how they were building their case. You know what? She's not going to answer any of these questions because she did it or he did it. Well, the judge can infer whatever he thinks. And if you don't answer, then he can infer that you probably did it. Or maybe you didn't. Whatever he feels. So that's self-incriminating testimony. Cross-examination beyond the scope of direct examination. A frequently used objection on cross-examination is that the testimony goes beyond or outside the scope of the direct examination, or that the question is improper cross-examination. An attorney who cross-examines may cover only the subject matter already covered on direct examination. Okay, question. Are you able, doctor, to form an opinion of your own based on the reports and the latest laboratory examinations as to the need for more tests? Attorney, I object to this question as going beyond the scope of direct examination. So they can't just ask any questions they want. It has to be related to the direct questions that the attorney called that witness on. Now, if they want to ask that witness certain questions, then they have to call that witness to open up, that side. Usually my judge, he just kind of opens it. You ask what you want. But, I mean, if you're following the rules of evidence, I mean, that's the way it goes. Usually that's the way you're supposed to do it. But instead of having to call the witness 2 different times, it's just like, let's get it out now. If you object to something, then, let's get it out now. The witness calls for expert testimony. Questions may be asked of a witness who is not an expert, just a lay witness, that call for more than factual answers. These questions will be asked by counsel as calling for expert testimony. If the witness on the stand can be qualified as an expert, an answer may be allowed. Otherwise, the objection will be sustained. Question, what is the value of this property next to your home? Attorney, I am going to object because this witness has not been qualified as an expert in the matter of appraisals. And it's true. If he's just a neighbor, he doesn't know. He has no idea. What he can guess. Well, that's not guessing. That's not expert witness. I mean, that's not expert testimony. Counsel is taking witness on a fishing expedition. The loose, scattered questioning of a witness that goes beyond the scope of the lawsuit is often called a fishing trip or fishing expedition. The use of the term means that the attorney is grasping for anything and everything that may or may not bring about damaging information. Question, why were you married 6 times before this marriage, and each previous marriage was to someone whose last name started with the letter T? Really? The answer, objection, Your Honor. Counsel has taken the witness on a fishing expedition. This question is not germane to the subject matter at hand. Has nothing to do with why they're getting divorced. Why the last 6 times this lady was married to somebody with the last name of T has no bearing on anything. Maybe it does, I don't know. But usually they'll object. Badgering the witness. Attorneys are not allowed to argue with the witness because it tends to produce inferences, not facts. Attorneys are also not allowed to badger a witness, nor demean any person who has testified in any way. To badger is to pester or nag a witness. Counsels are quick to object to such treatment of a witness by opposing counsel. Question, your answer is you think so. Is that all you can say? You think so? Come on now. You're not a stupid person. You can answer my question better than that, can't you? Or is it because you don't understand my question? And usually they will. I mean, that's badgering. You know what? Just ask them the question. If they don't know, they don't know. And usually they want to get the answer out and get the answer out. And we have a DA that's notorious for that too. Just wanting to be argumentative. But she likes to get the witnesses flustered and frustrated. But usually the other attorneys will object. And that's what they do. Your Honor, I object to counsel's arguing with the witness and badgering him in this manner. This witness has answered the question.
Is that, does the judge usually allow that? Is that something that he doesn't?
Well, if they don't object, then he just sits there. You know, it's not up to him to try their case for him, so it's not up to him to object, you know, to something or whatever. They have to object. The evidence speaks for itself. A common objection is that evidence speaks for itself. This objection is used when counsel may try to adduce lengthy explanations concerning material that is readily discernible from documents or photographs. Question: what does the scene depict other than the roadway itself? Attorney, I will object. If the court please, this picture speaks for itself. Try to pick up another one like in our court. You know, if they're going to bring in somebody's criminal record and they've already printed it and they have, you know, a certified copy. Well, Judge, you know, we've marked it, we want to introduce it into evidence, and then she starts asking the witness, well, isn't it true that on January the 1st, 1991, you were convicted of sexual assault of a child? Judge, we're going to object. They've already introduced the document. He was convicted, he served time, he already did it. Why do we need to go through this again? And that's what it's, the evidence speaks for itself. Okay? Privileged information. Certain information is considered as privileged between husband and wife, attorney and client, clergy and confessor, and physician and patient. The objection regarding privileged information is made by counsel for the person made by the confidential communications. What did your husband tell you as to his plan to commit this bank robbery? Attorney, I object. The question is asking for a privileged matter between husband and wife. You know, sometimes they'll come in, you know, some of the clients will come in, well, they hired an attorney, you know, and it's like, well, you know, we want you to pay child support. Well, I can't afford child support. Well, how much did you pay your attorney in a retainer fee? Well, that's privileged information. You can't ask that. And they can. You know, that's between the attorney and the client. They can't ask that question because that's the attorney and client. Anything that the attorney and the client speak about is privileged information too. So anything that has to do with them together is privileged information. Does that make sense? You have a crazy
I'm
look
just
on
saying,
your
because I
face.
remember, and as an example, maybe I wasn't paying attention too well, but I remember being in court and he was asking for fees, like for somebody, like for them to pay his fees.
Yeah.
And so the defendant's attorney was like asking the attorney questions, so he was on the record and giving his testimony as whatever questions that she was asking him, and she asked how much has she given you so far, and he had to answer, you know, it was like $10,000 so
Yeah.
far. So I don't know. I was thinking of that right now.
I don't know, and I guess it depends on the circumstance of what they're asking for the money for, I guess. You know, I guess every situation is a little bit different, but I mean, I wouldn't see where, you know, a judge would let that in, but you know, it all depends on I guess every situation is different. You know, if the guy's behind $30,000 in child support and he went and paid a $10,000 retainer fee for this attorney, yeah, maybe. The judge may want to know, yeah, you paid somebody $10,000 when you could have just given her $10,000 and now you'd only be $20,000 behind. So yeah, but no, you know what? I only paid him or her $200 and they said that they would take it on a retainer and I could just pay them. So it all depends. Narrative form of testimony. An attorney may object to rambling narrative type testimony, which many times will get into inadmissible matters. This type of objection is similar to the objection used when it's non-responsive. And it's the same thing as non-responsive. It's like, just answer the question. They ask a certain question, you know, just go on. And they may go on, you know, did you go to the store? Yeah, I went to the store. And the first time I went to that store, I was 3 years old, I remember, and I went with my aunt, and we went in this car, and you know, she bought some candy. That has nothing to do with anything. So usually they're going to object to that, and they just go on about stuff that has nothing to do with the situation at hand. And that's a narrative form where they just go on and just keep answering. Objections to expert witness. If an expert witness testifies about his or her qualifications and they are found not to be sufficient to establish his or her expertise, the court may rule that the witness is not qualified to speak as an expert. On the other hand, if a particularly world-renowned expert is placed on the witness stand, counsel may stipulate or agree as to the qualifications of the witness, meaning that he or she will not have to list her training and experience and accomplishments. And that happens all the time in our court too. You know, the state uses the same psychologists, psychiatrists all the time, so they come in and testify. And a lot of times, instead of wasting time going through the thing, when this guy's probably testified 50, probably more than that, maybe 500, 600 times in a case. I mean, on our kind of cases that come to court and testify that many times, they already know who he is. You know, so they're like, you know what, Judge, we'll stipulate that he is an expert witness. You know, he's testified before in our cases, and we'll stipulate to it. And if not, and the guy just kind of wants to be, you know, a jerk about it, he's like, no, put your qualifications on. So then they have to go through the whole thing. Okay, well, where did you go to school? How long have you been working? What makes you an expert in this field? Well, you know, I did a residency here. I worked for this company for 12 years. I've been doing this field in child psychiatry for, you know, or psychology for so many years. I've, you know, and then they have to go through this whole thing. So, but a lot of times they can stipulate to an expert. Mention of insurance. During certain proceedings, if an insurance company is mentioned or any reference is made to an insurance policy, defense counsel may object. The reason is that knowledge of a third party who may be responsible for payment of all damages may prejudice the jury in favor of the plaintiff. The jury may decide to give an excess amount to the plaintiff as compared to what the figure may decide if they were assessed against an individual. Where did you keep your insurance policy for the house that was burned down? Attorney, I object, Your Honor. Counsel knows very well that any inference to insurance will prejudice the jury. I ask the court to declare a mistrial. I've never seen it done, but you know, I guess so. I've never even heard that objection as to insurance, but you know, I guess so. Objections as a result of surprise. An interesting objection is the claim of surprise on the part of an attorney. This claim means that one of their own witnesses has changed his or her story or introduced material not previously known to the attorneys, contrary to what they were led to believe that the testimony would be. As a result of this surprise information, they were forced to plan a whole new line of strategy and attack, which may require asking the court to adjourn the matter to allow preparation time. Question. You are a fine, outstanding citizen, aren't you, Miss Jones? You have never been arrested, have you? Well, I was arrested twice on a weapons violation, and last year I was arrested for a felony DUI. This year, I've only been arrested 6 times for check fraud. Other than that, I have not been arrested at all. And you're bringing this person in as a fact witness to testify to somebody else, you know? So, you know, if they went in and said, you know, have you ever been arrested? No, I've never been arrested. Then they come in and say, well, for DWI, weapons violation, 6 times on check fraud. Yeah, a little bit of a surprise. Attempt to impeach one's own testimony or witness. To impeach a witness is to show that he or she is untruthful and has lied either in the past statements or an immediate testimony. If an attorney tries to impeach a witness he or she has called to testify, opposing counsel will object. Attorneys are supposed to bring in witnesses who are favorable to their own side to strengthen their case. They are expected to be familiar with the testimony that the witness will give. Question: didn't you tell me you weren't near the scene of the crime? Answer: yes, but I didn't understand the question. Question: and didn't you tell us yesterday that you saw everything because you live near the scene? Answer: yes, I thought you meant something else. Excuse me. Question: and didn't you tell your boss that you were going to change your answer because you didn't like the way you were treated on the stand yesterday? No, I mean yes, I mean I don't understand what you mean. And that's when they can impeach the witness, because he's changing his testimony because of maybe some way that he was treated. So it's kind of lying. Yeah, it's lying on the stand. Objections to exhibits. Anytime that exhibits are introduced by one side, either for identification or to be received as evidence, the opposing side has an opportunity to challenge the exhibit by objecting. Various grounds may be used for objecting to exhibits, including their relevancy, clarity, accuracy, and so on. Such objections will be noted. As a result of the objection, the exhibits will be either admitted or not admitted into evidence. The attorney: Your Honor, at this time, I offer defendant's exhibit D that has been marked for identification into evidence. Attorney: I object to the admissibility of the document as evidence because no testimony has been given as to where and when this document was originally made. For all we know, Your Honor, it could have been made this morning. The court: the objection is sustained. The exhibit will not be received at this time. Counsel can clarify when this document was made. So, I mean, you have to, when you're bringing in exhibits, I mean, they have to show why these exhibits should be admitted. Not, you know, well, she finished this rehab and we have this certificate. Well, it doesn't have anybody's signature on it. It doesn't have exactly the name of the course or the name of the place or anything, and they could have just printed it off the internet on any certificate. So no, I mean, we don't have the person who did the class, we don't have any of that stuff, so no, we're going to object to that exhibit coming in because they have no, they can't show that it's, they can't show its authenticity. They can't show that it was truly done. Okay? All right. Y'all have any questions about any of that stuff that we just covered? Objections? Y'all have any objections to the stuff we just covered? No?
I had a quick question, just real fast in the back in the exercises.
Yeah.
I just wanted to make sure, you said that the question is a good turnaround time for getting a transcript delivered to a client is 10 days to 2 weeks, true? Did you say you give yourself 10 days?
Where do you see that? What number?
Number 6 on part C.
Yeah. But, I mean, it all depends on who you go to work for. You know, like I said, the lady that I went to work for when I first got out, hers was 7 days, no matter what. So when you took it, you had 7 days to get it out, no matter what, unless it was rush. You know, the attorney said, you know what, we're going to trial, we're taking this exhibit on this deposition on Wednesday, we go to trial on Monday. I need it by at least Thursday, Friday to go over it over the weekend because we start trial on Monday. So if they tell you something like that, then yeah, you have to get it out quicker. But usually, I mean, you know, like mine in court is usually about 10 days. 10 days to 2 week turnaround. And if they want it quicker than that, then we talk about price. But it doesn't go up that much if they say, well, you know what, I need it in 8 days or 9 days. And your usual turnaround is 10 days. You know, you're not going to jack it up $5 a page because, you know, he wants it a day earlier than what you would have turned it around anyway. So Does that make sense?
On number 3, it says a notary public is used to swear in witnesses at depositions. They said it was true. Are we considered notary public?
Usually you have to be. Yeah. So usually the firm that you go work for will make you a notary. How to mark exhibits. Some of the objectives: discuss what constitutes an exhibit as it relates to legal proceedings, explain what marking an exhibit for identification means, explain how an exhibit is received into evidence, discuss how and where to mark exhibits either for identification or as received into evidence, discuss various procedures for marking different kinds of objects as exhibits, explain various parentheticals that relate to the marking of exhibits for identification or as received into evidence, discuss what happens to exhibits once they have been marked and received into evidence. The marking of exhibits is an art and skill in and of itself that requires common sense and practice. Exhibits are material items for physical evidence introduced by attorneys to corroborate and confirm oral testimony or to introduce new evidence based on an exhibit, all for the purposes of helping present their side of the case. Exhibits are usually marked for identification so that they can be discussed. After testimony is elicited to bring out the validity of that exhibit, it may be received into evidence. Okay, so first they have to just mark it. You know what, I have this letter, Judge, of that I want to have marked for identification. So they hand it to the court reporter, they put it on there. So I brought some exhibit stickers. Y'all kind of pass them around, and these are kind of what they look like. Just kind of look at them and pass them back. I'm going to give you some, and then I'm going to show you how to mark an exhibit, okay? So after it's been received into evidence, then, you know, they mark it, offer it, then admit it.
Can I take one?
Huh?
Can I take one?
No. Put it back. No, you can't. Always, you want to teach a class now? No, actually, I mean, I was going to give y'all some anyway because I want you to fill it out, okay? So I want you to know how to do it. And that's why I brought the exhibit, so the exhibit stickers. And then I'm gonna put it up here on the board for those that are doing it online. So what constitutes an exhibit? Physical evidence may include guns, bullets, medical records, marriage certificates, soil, quicksand, any of that stuff. Anything that you can put your hands on, you know, or whatever, is physical evidence.
Can you, I'm sorry, I probably wasn't paying attention, but can you tell me what received into evidence means, like a definition of, okay, yeah, you marked it for identification.
Yeah. When the court says, you know what, it's been received into evidence, that's when it's received into evidence. Now, what they, you know, the order is first you mark the exhibit, then you offer the exhibit, and then you'll find out whether it's admitted. The exhibit. Okay? So what they're going to do, attorney, judge. Okay? So what they're going to do is first they have to mark it. Then they have to show, you know, okay, is this a document? Are these the pictures that you took of your house? Yes, they are. Don't tell me what's in them, just tell me what it is. These are pictures of the house that I took, you know, and it shows the different rooms. Okay. Judge, I want to offer them into evidence, and I'm going to show them to opposing counsel for objections. So they'll go through there and look at them or whatever, and if they don't think, you know what, there's no way she could have taken this. She's been in jail, you know, She's still in jail. You know, so how would she have taken, you know, these exhibits or these pictures? You know what, I want to take this witness on voir dire. Okay, did you actually take these pictures? Yes, I did. When? Well, before I went to jail. Oh, okay. Well, then they're okay. Well, then, Judge, we have no objection. No objections from anybody? No objection. They'll be admitted. So that's what I was telling you. On your sheet, on your sheet, you're going to mark, you're going to have, you know, like the way that I do it, I do states, ad litem, mom, dad. It was like, you know what, number one, it was marked. Judge, we want to offer it. Any objections? No objection? Admitted. Did everybody take one? Take one of each.
Oh, one of each?
Yeah.
I just stole one.
Now you're stealing. Yeah, take one of each because I'm going to show you how to mark it, and then we're going to kind of go through this little process, and then I'm going to. So that's how you do it, and then, you know, at items one, you know what, Judge, we want to mark it, we want to offer it. Any objection? Yeah, I have an objection, Judge. This wasn't the person who took the pictures. She was in jail the time that she did it. There's no way that she could have done it. Did you do it? Well, no. I mean, my sister was the one. Well, no. Then you know what? They're not admitted. So then you don't put an A right there. So that's how I keep track of whether my exhibits were admitted or not. It was marked. It was offered, but it wasn't admitted. Well, State's Exhibit 1 was marked, it was offered, and it was admitted. Okay?
If it wasn't admitted, it's not received into evidence?
It's not received into
So the-
evidence if
the
it's
whole
not admitted.
process is marking, offered, admitted is the whole process of
Yeah.
being received into evidence?
Yeah.
Okay.
Marking exhibits. To mark exhibits properly, a reporter should have a variety of supplies on hand. These supplies may include an exhibit stamp or stamp pad and other marking materials. I don't even know, I've never even seen an exhibit stamp, but whatever. So I have the stickers, you know, and that's what I've always used. The firm that I work for, you know, they had them. That's how the county does it. We have, you know, exhibit stickers or whatever, so. Miscellaneous marking materials. Among the paraphernalia that one might use in marking exhibits might be a felt tip pen, variously sized self-sticking labels, which is what that is, paper clips, stapler, and staples, tags with ties, variously sized envelopes into which to insert exhibits, and so on. I mean, I don't have all that stuff. I mean, they bring what they want it to come in. You know, and sometimes they'll bring pictures, and there's 50 pictures. Well, Judge, you know what? Instead of marking every picture as individual exhibits, we're just going to mark the outside that you put the little pictures in, that little cover, that little envelope thing. We're just going to mark that as one exhibit. Any objections? No? Okay. Then it can be admitted as one exhibit. Where to mark exhibits. Physically marking exhibits requires placing identifying information somewhere on the exhibit. If it is large, cumbersome exhibit, the exhibit information should not be placed on a tag and then tied to the exhibit. Should be placed. If it is a document or photograph, markings can be placed on the upper right-hand corner, lower bottom portion, or if necessary, on the back of the document. So if I was going to take this right here, if I was going to take this thing right here, and somebody wanted to mark it into evidence, and they say, you know what, Judge? We're going to mark it as petitioners. Petitioners exhibit number 1. Okay. Well, you can see right here that it has pertinent information on here. So you don't want to go, okay, I'm going to go ahead and mark it. And you mark it right there. No. No. Okay? So if it has pertinent information on there, you don't mark it on that pertinent information. Okay? So what you need to do, and what I always do, is it's always the right bottom corner, unless there's pertinent information there. So this is the way that I would have marked it, right there. Bottom right corner. You in the back.
Who's the petitioner, who's the respondent? Like, usually the stickers I see are just plaintiff, defendant.
Yeah.
Things are so foreign to me.
These are the ones that we use in my court. And the ones that I brought today are State's Exhibit, just the exhibit, which is usually the ad litem, just because they don't have ad litem for us. This is the State's Exhibit, Petitioner's Exhibit, and Respondent's Exhibit. Okay? So the person who usually brings the lawsuit is the plaintiff. Okay? So that's going to be the person, you know, and they'll tell you, you know what, Judge, we're going to need this marked, and I want to have it marked as plaintiff's exhibit number 1. So you already know. Well, the defendant's not going to come up and say, you know what, Judge, I want this marked as plaintiff's exhibit number 1. Huh. The defendant's not going to admit an exhibit for the plaintiff. So usually they're going to say it. They're going to say it, but you know, a lot of times, and if you don't know, just ask them, how do you want this marked? Oh, we want this marked as plaintiff's exhibit number 1. Okay.
But is the petitioner the defendant? And
The
state's
petitioner is the one bringing the lawsuit. So the petitioner is the plaintiff. The respondent is the defendant. And then you have the state, who is usually the petitioner. So I don't really use the petitioner unless we have some other different kind of case that comes in, but I just have those stickers. So I just brought them just because it's some other different kind of sticker. So usually, you know, I'll use these blank little exhibit stickers. You know, if they say, well, I want this marked as ad litem's exhibit, you know, number 1. Okay? Y'all got this, right? Okay. So here's your exhibit. And it's petitioners. Petitioner's exhibit. Okay? And the way that it looks is like this, and then it has like a little line right here. Okay? Y'all see that, right? Okay? So it says, you know what, Judge, we want this marked as petitioner's exhibit number 1. Okay, so they bring it to you. Here's petitioner's exhibit. You mark it in the lower right-hand corner, and if there's something down here, then you go up to the upper right-hand corner. And if the complete thing is covered with pertinent information, then put it on the back. Okay? But you try to go lower, upper, lower, upper. And if not, you know, let's just say that there was something here, and you had to put it in the middle because there's absolutely nothing there, then, I mean, just put it where you can. But if there's something on the whole page, you know, there's numbers or, you know, just whatever, sometimes you can't do it, then you put it on the back. Okay? But this is the way that it would look. Okay, I want to mark this as an exhibit. Okay. What you're going to do is, I want it marked as petitioner's exhibit number 1. So what you write, number 1, do it. So I'm asking you to mark this exhibit. I want this marked as petitioner's exhibit number 1. So what you do is you put your initials on the side. Can you see? And then you put the date. So it's 9, what's the date? 8?
At 7.
7?
It's over.
Hey. Go sit outside for a little bit. No more questions. You can't ask any more questions.
That's so many.
I know. That's what it looks like right there. Okay? So I asked you right now, and you should have State's Exhibit. I just handed you State's Exhibit. You know what? I want that marked as, you know what, Judge? We're on number 12. So I want you to mark it as State's Exhibit number 12 right now. And how you would do it. Correct. Real easy, guys. Real easy, real simple. Okay? The only thing that's going to change is if you get the one that just has exhibit. Okay? And now the guy comes up and he says, you know what? I want this marked as ad litem's exhibit number 1. I don't have any ad litem stickers. Don't freak out. You have these. Okay? You have the blank ones. All it says is exhibit. No big deal. You write ad litem. One, initials, date. Guys, very important, very important. Date, initials, number, correct sticker. Very important. Okay? Y'all got that?
I have a quick question about your initials.
Okay.
What do you do when, like, I go by my middle name, I don't go by my first name.
Okay.
So what do? You just choose the initials that you usually go by?
Well, it's
or do
more
you
for
go by-
identification. So if you're going to be able to identify it, you know what? Well, she marked the exhibit. Who's she? Well, DZ. Oh, who was that? Darla? No, that wasn't a lady. That was David. David marked the exhibit. Oh, okay. Well, I thought it was Darla Zapata. No, it was David Zarate. Oh, okay, okay. You have to be able to identify it. So however you're going to be able to identify it, it doesn't matter. As long as it's your initials. If you go by your first name, then you mark it on your first name. You want to put all three, put all three. But it's what you're going to use and keep it uniform. So you use it all the time. And that's what you use. So that your judge knows, the attorneys know. Well, and what's your first name? I mean, do you care? Huh?
Maria.
Maria. Your last name was?
Algerat.
Algerat. So, I mean, one time you come up and, you know, and it's the same trial. And now you have Maria, A, right? Marie, M.A. Okay? No big deal. Good to go. Well, you know what? Now we're down the road. Still on the same trial. ad litem comes up and he goes, you know what, I want this marked as ad litem's 15. Okay. No. Y'all see what I did? Now she's going by Carmen Al-Jarrah. I don't care what you go by. Keep it uniform. You're going to use Carmen all the time, then use C, period, A, period, all the time. And if you don't what? You don't want to get mistaken, then do M, C, A. Maria Carmen? Or Carmen Maria? I'm sorry?
Maria del Carmen.
Oh, okay. So would it be D?
Yeah.
Okay. Well, I mean, and it doesn't matter. It doesn't matter. So, I mean, keep it uniform. So however you want to do it, keep it uniform. The only way it's going to change is if your name changes. You get divorced, something like that, and you go back to your maiden name or, you know, whatever, then I guess, you know, I guess they'll know. But I don't know that you're going to get divorced in between a trial. Maybe you will. I don't know. Keep them the same to the end of that trial. Okay? So that they don't get mixed up and there's not, well, I don't even know who CA is. MA has been marking all the exhibits and it goes up to the fourth court and they have no idea, you know what? We don't see another transcript from another person, MA. Who was MA? All these exhibits were marked by CA. We have no idea. Keep it uniform. That's the only big thing. Imagine that. Yes, you in the back.
I read something about tags.
Yeah, I mean like on a gun or, you know, something like that. They're gonna have tags and we don't have any, we don't use them, but it's just a little, it looks like, I mean, kind of like this, just a little tag and it has like a little string on it. So you can put the string through and put it through there and then it, you know, you draw it tight and then the string and it just kind of dangles.
Do they provide that or we need to have those?
You know, I guess they'll provide them. I guess the county provides them. I've never asked for them because we never use them. You know, so, I mean, if somebody brought a gun in, I'd probably mark the stock of it. I don't know. You know, I've never had to mark a gun. You know, and, you know, and not to get too graphic or whatever, but, you know, they brought in some panties one time of a little girl that was sexually abused, but they brought them in a bag.
Right. But if
So I just kind of marked the bag. I mean, I didn't have to mark the garment itself. So even if it's a t-shirt, headband, whatever, it doesn't really matter. I mean, as long as the sticker will stick on there, great.
Even if it's like a fake engine, for some reason they had to break it in.
Yeah.
Even though a sticker really will fit somewhere, it won't be considered that's too little. It would be better to use a tag on this.
Yeah, and you may have to use a tag on it. And just tell them, you know, hey, look, you know, I'm going to mark it with this exhibit sticker because I don't have any tags, and then later I'm going to put a tag on it. Just make sure that everybody knows. Hey, Judge, I don't have any of the tags that have a string on it or whatever, so, you know, I'm going to mark it with an exhibit sticker, and then I'll come back and mark it. Is that okay? I'm afraid the sticker's not going to stick on this engine or on this whatever. Okay? Finally, a good question. Crazy. No, that was a good question. That, I mean, that is because, I mean, you never know. You never know. And I've seen guns marked like that, you know, and you know, for example, you know, because you ask, well, I mean, where would, if they bring a gun, you know, where am I going to, you know, and the gun's like that, and then the stock comes down like that, and here's the trigger. You know, and it's like, well, I mean, where do I put it? I mean, because it's not, if I put it here, it's just going to roll off. Well, no, you put it right here. Put it through here, where the trigger is. Put the string through there. Bring the tag through the string, because usually it has a piece of string that's connected. So you bring it through the string and then pull it tight. Y'all know what I'm talking about? I wish I had one, but I mean, that's where you would mark it, and then it just dangles from there. Okay? So that's where I've seen it, you know, and on pistols, it's kind of the same thing.
I have a question.
Yeah.
I'm just probably confused on this, but where you mark it, for example, like states exhibit number 1, MA, and then, or MO and then A, where do you put that? Do you put that on a separate sheet, or does it actually go on here for you to keep track of when it's marked, offered, and admitted?
No, the MOA stays on your sheet.
On my, okay.
And that's where, you know, you have, that's your separate little sheet. And we went through it in one of the first chapters or whatever. God, I can't remember. Because I don't really use them. What was it called? You remember?
It's never gone over that one.
The what?
Information.
Information sheet. So what that has is like all of your witnesses, all of your exhibits, stuff like that. Okay? And it's going to go on your information sheet.
In your court, do you have a problem with keeping up with the exhibits? Because I've heard court reporters that they really need to stay on top.
Oh, yeah.
Because some attorneys can walk away with these.
Oh, yeah. You have to be careful because,
Responsible for these.
yeah, and you're responsible. And sometimes, and you know, sometimes the attorneys don't do it on purpose, but they'll do it. You know, they're just, oh man, you know, we lost. You know, we're picking up stuff, and, you know, get all this stuff together, and they pick up the exhibit and they just go. Well, where's exhibit number 6 that was admitted? I don't know. You don't know. And you're kind of responsible for that exhibit, because if it goes up on appeal or something happens, you're responsible for that exhibit.
So how do you go about getting it back or finding where it's at?
Just call them. You know, hey, did you pick that exhibit up? Oh, you know what, Dave, I did. You know, I'll bring it by or whatever, and you know, or if they're still out in the hallway, run out there. Hey, you know, check your stuff. Did you pick up exhibit 6? Oh yeah, here it is. Here. I'm sorry. You know, most of the time they don't do it on purpose. You know, they just not thinking. I mean, it's just so quick, and they're trying to get out of there or whatever. So, but like what my clerk does now is my clerk is responsible for our exhibits. So what she does is she puts them in a brown manila folder or whatever, and then she has me sign off on a sheet that they were all there, they were all marked properly, and everything is there, and that she has them. So this way, if they ever come, it's like, where are the exhibits? I don't know. You know what? I gave them to her. Well, let's check. So she keeps them in a folder. She's really crazy organized. Keeps them in a folder. Oh yeah, here it is right here. Okay, I have them up here. She knows exactly where the exhibits are. Pull them out. There it is. But yeah, I mean, like in a deposition, stuff like that, you're responsible for the exhibits. So keep track of them. Unless they say, you know what, we're going to go ahead and take that exhibit back. You make sure it's on the record. You know what, let's go back on the record that you took this exhibit back. Okay. And then just go back on the record, you know, hey, I'm going to withdraw this exhibit because we're going to need it at the time of trial, but I just want it introduced at the deposition, blah, blah, blah. Okay. Or they'll just say, you know what, no, just attach it to the deposition and go on. Okay. But you're responsible for that exhibit. Okay? Procedures for marking exhibit. Exhibits are clearly marked in such a way that exhibit markings will not be erased or smudged off. And it's kind of, you know, you can kind of smudge them a little bit, but you want to make sure that it's on there pretty good. So you don't want to use a pen that's going to kind of smudge, you know, real easily or whatever. So if, you know, you need one of those ballpoint pens, you know, just make sure that it's going to stay on there and that you have a good pen to mark it. You know, what I do is like, you know, and sometimes attorneys want to keep talking. You know, hey, you know what? I want to mark this exhibit. All right. Hey, Judge, you know, and I'm just writing, and they're like, well, let me see that exhibit. Well, I haven't marked it yet. Well, why haven't you marked it? Well, you have to allow me, be quiet, allow me to mark the exhibit. You know, I can't take down what you're telling the judge to. I can't do two things at one time. Let me mark the exhibit, I'll give it back to you, then we'll have it.